Good afternoon. Thank you for joining us today. My name is Catherine Saldana. I'm one of the mentor attorneys with the Dallas Volunteer Attorney Program. Today's CLE is a very important one with many of our clients, informed lawyering. Pardon. We are fortunate to have Rachel Elkins speak with us today because she really is extremely experienced in this area. She presently serves as a pro bono counsel in the Dallas office of Haynes and Boone, where she leads the coordination of the firm's global pro bono program across all 19 offices. In this capacity, she works with attorneys on firm-wide pro bono initiatives and provides direct legal assistance to individuals in need of critical services. Prior to joining Haynes and Boone in July of 24, she spent 6 years at the Genesis Women's Shelter and Support in Dallas, where she served as Director of Legal Services. There, she represented survivors of intimate partner violence and built a trauma-informed legal advocacy program. She earned her JD from Southern Methodist University, Dedman School of Law, and her BA from Boston University. Please join me in welcoming her here today. Thanks.
Thank you. I'm so glad to be here. Good afternoon, everyone. As mentioned, my name is Rachel Elkin. I'm the pro bono counsel at Haynes Boone. Today, we're going to be exploring and talking about trauma-informed lawyering and specifically how adopting this approach can transform our advocacy as attorneys. So my goal is to help us recognize the way trauma manifests in our clients' lives, help understand its effect on legal processes, and integrate practical strategies to build trust, empower our clients, and protect our own well-being as practitioners. So we'll go ahead and jump in. So when many people think of lawyers, they imagine certain traits, like they are cold, analytical, ruthless, argumentative, strategic, and of course, hyper-focused on zealous advocacy. These attributes can be useful in engagement, and they're certainly good for Tom Cruise in his movie career, but it can also inadvertently create distance and suspicion, especially for clients who have experienced trauma. So on the flip side, pro bono work often requires us to put an emphasis on empathy, compassion, gentleness, being nurturing, and of course, emotional attunement. So despite what all of our lead training may have said, these qualities are strengths, they're not liabilities. So trauma-informed lawyering bridges these two worlds, marrying the strategic legal practice with an empathetic, client-centered approach. The question is not which mode is right, but how to integrate them so clients can engage safely and effectively in their cases. So what specifically does it mean to be trauma-informed? At its root, it places the realities of the client's trauma at the center of how you engage with your client. So it requires us to connect behaviors to trauma rather than judging that behavior or dismissing it as a character flaw. So at its most basic example, it asks or requires us to ask, what happened to you rather than what is wrong with you. So specifically, this shift in the way that we approach our clients, the way we talk with them, it is designed to reduce shame in our clients. It builds rapport between us to develop the attorney-client relationship, and it lays the groundwork for more accurate fact-finding and better legal outcomes, which is, of course, what we always want as attorneys. So when you're talking about trauma-informed skills, many of us will use these skills for clients who may have come from historically marginalized communities, but I do want to emphasize that trauma can impact anyone. So our clients, the ones that we're talking about who have experienced trauma, carry layers of lived experience that shape their engagement with the legal system. Problems rarely exist in isolation. So you look at issues like housing, employment, family, health, and the legal issues all often interlock. So when we're treating the whole person, a trauma-informed approach practice recognizes this complexity and approaches representation holistically. It's necessary to understand that these meaningful solutions require context, not just our case strategy. So I like to use this example of, this is Mrs. T. She is our example today for how these intersectional problems can compound and how it all leads to our understanding of treating the whole person and understanding trauma that people have been through. So at its most basic, what you're trying to do is understand the complexity and totality of a person's lived experience. And that includes understanding the way that factors can pile onto a person throughout their lives. So if you look at factors like race, religion, education, class, disabilities, family, children, income, marital status, these, and especially education, these all impact the way that Mrs. T views the world and the way that the world views her. They intersect to impact a client's risk of trauma, their access to resources, and their experience with legal institutions. So they also can't be separated from each other. Recognizing these intersections, the way that the world views someone based on how they are labeled and the way that the person interacts with the world. Recognizing these helps us tailor communication, anticipate barriers or adverse reactions based on past experiences, and it avoids a one-size-fits-all approach that can unintentionally harm or alienate our clients. So I want to dive into a little bit about trauma. You're going to get a little more science that you might have thought that you were going to be getting, but I think it's important to understand how trauma actually impacts our bodies. So trauma is not monolithic. What we call big T trauma, which is a lot of people associate or have the understanding of what trauma is. This includes major overwhelming events like natural disasters, war, severe accidents, or isolated sexual or physical assaults. In contrast, little t trauma involves repeated or subtle experiences such as coercive control, emotional manipulation, workplace harassment, microaggressions, chronic invalidation. These experiences steadily erode a person's sense of safety and agency. So little t trauma is often minimized because it lacks a single defining event, but its cumulative impact can be extremely profound. So we don't differentiate between the harm that either big T trauma or little t trauma can cause to a person. It's just differentiating what led to that trauma. So now we're going to get into the science a little bit. When we're thinking about trauma and the brain, it's helpful to think of your upstairs brain and your downstairs brain. So this is where we get into the question about what happened to the brain or what happens to the brain when it experiences trauma. So your upstairs brain handles planning, logic, things like imagination and play, and it also is where empathy and morality take place. This is your rational brain. In contrast, the downstairs brain manages your survival instincts. So anger, fear, impulses, and basic rudimentary functions. This is your so-called lizard brain that operates on instinct, not rationality. So when the brain perceives danger, what happens is the downstairs brain will hijack the upstairs brain. This is because survival takes priority. So you are literally going into survival mode. This is adaptive in crisis, meaning it is how you stay alive, how the brain keeps you alive, but it can also impair your logic, memory, and communication, especially when we're talking about in legal settings. So understanding the physiology of this helps us interpret client behavior more accurately. So when we're in this state where the downstairs brain has taken over, what has happened is the brain sensing the danger, and your survival alarm goes off. So the downstairs brain hijacks the upstairs brain, and this is when you go into what we call fight, flight, or freeze mode. The other fourth addition to that, those three words, is fawn. So that would be when you're trying to appease someone to get them to calm down because you have recognized danger in them. So what's important to remember at this moment when the downstairs brain has hijacked the upstairs brain is that this person is not capable of rational thought at that moment. And some of you may recognize this if you have young children, when they get extremely overloaded, when they get really just have a meltdown, you cannot talk to them. You can't reason with them. You can't yell at them. They are just not in a position to hear what you're saying. It's because their brain is literally not in a position to hear what you're saying. So this is similar when any person, regardless of age, goes into this survival mode. So you might be looking at someone who appears argumentative, outwardly aggressive, but you could also be looking at someone who is withdrawn, avoidant, or unable to recall details coherently. So it's important to remember that this isn't defiance or deceit, it's physiology, it is their brain. So recognizing these patterns allows us to de-escalate, pace our questions, or adjust our strategy, and create conditions that help the upstairs brain come back online. We're not just going to let someone live in that survival mode. We want them to come back online. And there are numerous health reasons because of that, let alone getting your client to be able to properly answer questions for you. So I like to show this illustration because I think it's useful to recognize that you can't always recognize when someone is in fight or flight mode, because a lot of the physiological responses can happen below the surface. So if you see the noticeable effects on the right side, I'm sorry, on the left side, you can see a lot of familiar responses. So increased heart rate, shallow breathing, your mouth goes dry, pupils get dilated. You can observe those in other people. But these ones that are the hidden effects are not always obvious. People may be good at hiding them. So it's important to recognize what could be happening below the surface. I also think this is a good way to see the long-term effects of trauma, and we're going to talk about those in a minute. But especially when it comes to the toll that trauma can take on your body. So if you see down here that cortisol is released, excess cortisol is released, which depresses the immune system, which is one of the hidden effects of fight or flight. Think about what could be a long-term effect of having a depressed immune system or excess cortisol released. Digestion slowing, liver releasing glucose. These are all things that can have long-term physical effects on a body. So what is happening to a person who has spent 20 years in fight or flight mode? They have a suppressed immune system. What about years of increased blood pressure? What about years of increased heart activity? Those can have long-term effects on someone who has experienced trauma. So for legal practitioners, I think it's important to understand especially how trauma affects memory. This is a big one. So I wanted to kind of lay out the actual path that follows for how memory is stored and understood during a traumatic event. So much of how we represent our clients represents or is based on the accuracy of their storytelling. The success of their legal case will depend on whether we believe them, whether a judge believes them, will the other side be able to poke hole in their stories, and especially how are they perceived when they're testifying, when they're telling their story. So when the traumatic event starts, the amygdala floods the body with stress hormones. What happens then is the amygdala is where, which encodes our emotional experiences. So the memory of the event is stored in the limbic system, which is the process for nonverbal gut reactions. So what that basically means is that the memory is actually stored in your body as a fragmented sensory impression rather than coherent narratives. So this makes it hard to recall events in a linear, organized way. You may have encountered this when you have been interviewing or talking to someone who has experienced trauma. If you ask them, when did this happen? They may say, well, it was right after my daughter's birthday. And you're going to have to say, okay, when is that? Like, what is the date with that? So you're going to have to, that's a good example of adjusting your questioning, because for that person, they remember the feelings, they remember the sensory information, they remember how it felt, and maybe what was happening around them. They are not able to understand, okay, well, it was October 12th. That is why it's important to be patient and be gentle when asking your questions, asking clarifying questions. So when you're able to notice these things, you'll be able to make the space for the client to come back online. So the way that I use this in practice, for example, when I would have a client who was asking for a protective order on the stand, and I would ask her to relay the events of the abuse or of the incident, and I could observe, she's being re-triggered, she's going into survival mode. I will ask her to recount her feelings. I will ask her to say, what did you hear? What did you smell? Did you taste anything? Those sensory perceptions helps the brain relive the experience. It's not pleasant for anybody, but that also gives credibility to what the client is relaying about the incident. I definitely like to ask the question, how does your body feel right now? Like when you're having to recount the memory of this experience, how does your body feel? They'll often talk about like headaches or stomach aches or actual physical responses that again lend credibility to the experience, but is emblematic of how the memory has been encoded in the brain. I have heard many times the incorrect belief that if a child wasn't physically harmed or that the trauma happened when they were too young to remember, then the child is okay. But I really want to emphasize today that the younger you are when you are impacted by trauma, the more you're impacted. So this is not something that you can grow out of. This is not something that you can move on from. It's actually more helpful to think about it as if you've damaged the roots, if you've damaged a child's brainstem, then that impacts their ability to grow stronger, to develop in the ways that they're supposed to. So trauma that occurs before the age of 5 has outside effects on the brain development. So the less developed the brainstem at the time of the trauma, the more pronounced the long-term impact. Additionally, as people age, they can accumulate coping skills that can mitigate harm. But early adversity often leaves enduring cognitive and emotional imprints. So this context helps explain why some clients struggle with memory, struggle with attention, or emotional regulation even years later. To learn more about this, development specifically, I really recommend the book The Body Keeps the Score by Vessel van der Kolk. He is an expert in this field, and he's kind of the authority on explaining how early life trauma can have impacts on people as they grow older. So what are some of the things that we can expect to see or we can look for when we are talking with people who have experienced trauma? So the first two common patterns are flooding and minimization. So flooding occurs when traumatic memories blur together. Asking about one event may trigger recall of others. So that's helpful when you need to keep someone on track. Saying, okay, I wasn't asking about your daughter's birthday party. I was asking about when did this event happen? Can we just get back on track? Minimization is a protective mechanism. So where clients may downplay the harm, justify the perpetrator's actions, or compare themselves to others who have had it worse. So instead of challenging these reactions head on, we can validate their coping strategies while gently grounding the conversation in facts. For example, when I would meet with a client who said that because her abuser didn't physically hit her, that the abuse wasn't that bad, I would then gently ask her, did you feel scared? And whenever she would say yes, I would then respond, do you think that's how someone who loves you should make you feel? So just gently grounding the conversations in the facts helps with these common manifestations of trauma. So another common manifestation is dissociation, which is another survival response, mentally locking away memories to avoid feeling overwhelmed by them. As trust builds in that attorney-client relationship, clients may disclose crucial facts later on in the case. Again, this delay isn't about deception, but it's protective timing. Additionally, when recounting trauma or recounting the experience, the body can re-enter the survival mode. So that's what I was referring to when I would have a client on the stand who would feel like she was living it over again. So grounding techniques like orienting someone to the present, noticing sensory details, guided breathing, these can help clients regulate and engage. So obviously, if you're on the stand, you're kind of limited in how you can do grounding techniques, but something like describing how the body is feeling is one of those grounding techniques. It's noticing the sensory details about what's going on around them, and also orienting them to the present of where they are and what's going on right there. But if you're having something with a client in your office who is experiencing that, then it could be fidget toys, it could be getting them some water, it could be doing guided breathing with them, but noticing when a client has been re-triggered like this and bringing them back to the present. So I mentioned before the long-term effects of trauma. It can have very significant impacts on the body and on the mind and its ability to function. So trauma can alter your brain processing efficiency, how well you process information, can change your gene expression, and it can change your measured IQ. So someone may not have just been born stupid. They may have had actual traumatic experiences that have lowered their ability to succeed in that brain development area. In the cognitive area, survivors may struggle with problem solving, concentration, even delays in language. And of course, physically, trauma correlates with hypertension, obesity, heart disease, diabetes, sleep, and eating disorders. So this is a whole array of long-term effects of trauma that can be experienced on the body. And again, these are not excuses, they're explanations. So they inform how you want to make reasonable accommodations and set realistic expectations for case management. So I want to spend a whole slide on behavior and emotional effects because trauma can commonly manifest as depression, anxiety, suicidal ideation, poor emotional self-regulation, aggression, and impulsivity. So clients may also engage in risky behaviors and have difficulty recognizing and naming emotions. Again, these are not excuses, but explanations. Behavioral and emotional effects of trauma are usually where your bad facts will come into play. So why was she engaging in these behaviors? Why was she doing XYZ when she should have been at home with her children? Or why did she go back to him? That's a great one to ask. You as her advocate can help a court understand. For example, while Your Honor, he used alcohol to self-medicate and avoid confronting his traumatic experiences, and that's why he did XYZ. It doesn't mean that your client or this person should escape consequences for truly bad behavior, but it also shows an ability for them to accept responsibility and to hopefully get help that they need. That's kind of the best outcome of all of this stuff. So again, this is not advocating for lack of consequences. And I also want to mention it doesn't advocate lack of consequences for someone being a bad client. So we're going to talk a little bit about the ethics of providing representation to people who have experienced trauma, but this does not mean that you have to just keep someone on as a client when they are doing things that may risk their case. If they ask you to do something that's unethical, you are still bound by all of these ethical concerns as an attorney. And it is also your duty to explain that to the client, to say, I cannot continue to represent you if you are going to engage in these kinds of behaviors, but it doesn't judge them for those kinds of behaviors. And especially the non-judgment is very important because a lot of survivors of trauma will have a heightened sensitivity to shame and guilt, coupled with low self-efficacy. So this can complicate their decision making. So low efficacy means that people don't believe they are capable of doing good in life, that they are not capable of rising above their circumstances, that they are not capable of having a good legal outcome because they are the problem. So you can see how having this trauma-informed stance avoids moral judgment and instead focuses on safety, stability, and I think most importantly, incremental progress. So when we're talking about how this can show up in your legal practice, this will show up as fragmented storytelling and non-linear memories. Clients may avoid anything associated with the trauma, including the legal process itself. So again, if you have a client who no-shows, if you have a client who changes their story, these are all considerations that you need to take in terms of taking on this client, but coming from a place of your ethical responsibilities and whether the client is ready for this experience. That's a big thing that when I was at Genesis, we would ask a lot or we would evaluate a lot is this client actually ready to go through with this pretty harrowing experience that the work process can be? And it's not shameful to say you're not ready, but that is part of your ethical obligation. It's part of the way you can be a good advocate for that client is to say you're not in the right place to actually deal with how harrowing this is going to be. So if they are, or if they do enter, into the legal process, recounting events can also be re-traumatizing. So especially when clients feel powerless or confronted by authority, if you have to challenge them on part of their story, if you have to prepare them for what it's going to be like to be cross-examined, those are ways that you can be trauma-informed. You are not being insensitive by saying, you're not ready for this, or I don't think you're being truthful with me about this. That is asking for accountability, and it's putting you and your client in the best position to succeed. So the way you can anticipate these dynamics helps us structure the interviews, prepare for testimony, and of course collaborate with the client on pacing of the questions, and so that they can actually feel like they're participating in the presentation. So some additional tips that I kind of found that work over the years. It's so important to be incredibly detail oriented in telling the client kind of every little detail. So I would drop a pin on a Google map with the exact location to park. I would say, here's what you can expect when you park. Here's how crowded the parking lot is going to be on this particular day. Here's how early you should get there. And then you can even give them a detailed map of the courthouse. Here's where you go. Here's the mural that you're going to be looking for. Bring bottles of water, tell them to bring fidget toys if they feel like might want to bring something that gives them comfort through their religion, like a rosary. Those are things to tell the client to be aware of. The other thing to tell them to be aware of, I have found, is how long they're going to have to wait. That court is very much a hurry up and wait situation, so that it's also very helpful to tell them, I want to make sure not to forget this point, that you as the attorney may appear friendly with opposing counsel. You may have to exchange pleasantries or niceties. That is part of you being a professional. That is part of you doing your duty as an attorney. That is not you chatting away with the opposing counsel like they're your best friend. That is not you undermining the client. That is your responsibility as an attorney. So I think that is very much something to tell a client to expect or to understand as well, is the relationship that we as attorneys have with our fellow attorney community. So more details about how to put this into practice. So first and foremost, trust is the foundation of a positive attorney-client relationship. Let the client tell their story at their pace. Expect these stop and start narratives and late emerging facts. That is so crucial. That is really important. But at the same time, it's important to be present and an active listener so you can redirect the client if they go off track. But you are also building time to create rapport with your client. You're also building time to validate their experiences and their feelings. That is also so incredibly important. So it really goes back to that question of what happened to you, rather than you are a bad person for doing this. So asking those questions and then being able to say, thank you for telling me this. That must have been really hard to say. However, I want to go back to this point that you made about XYZ, and I want to just ask some clarifying questions. But weaving in validation of their experiences and their feelings is incredibly important. Prepare the courts or opposing counsel, where appropriate, for accommodations such as breaks, plain language explanations, and the use of timelines or visuals. So what I will often talk to a client about, I will say, if you're being cross-examined, it is totally okay for you to tell the opposing counsel, I'm so sorry, I didn't understand your question. Can you ask it again? Can you ask it in a different way? That you're not going to get in trouble for doing that. And of course, I tell them not to answer a question they don't know the answer to. But that also is helpful for helping the client with what to understand about the process and what to expect. And that, again, creates that foundation of a positive attorney-client relationship. Above all, I think it's really important to prioritize the client's sense of agency. So that is both therapeutic for them to feel like they're involved in their own representation, and it's strategically beneficial. I hope this is obvious, but you have to be really careful about not making false promises. If you are successful in building that attorney-client relationship, your clients are going to value your opinion and believe pretty much anything that you say. And of course, that is ripe for manipulation or being taken advantage of. So the most it's never a place to say, we're going to win, we're definitely going to do this. But a lot of times, what's most helpful is just to say, no matter what happens, I'm here for you. No matter what happens, I'm going to fight for you. That is a good way to say that when they say, make me a promise or something like that. So what you're doing when you're empowering the client is you are letting them identify their own legal goals. I think that's a really important thing to make sure to ask for. A lot of clients who have experienced trauma or who don't have faith in the legal system don't know what their options are or don't know what the end goal is possible. So a lot of times it's helpful to say, if I could just wave a magic wand, what would be the end result that you would want to come out of this? And then you can kind of work backwards from there to adjust what is possible. And it's certainly to define success looks like for them. So present the options in clear, accessible terms and support informed decision making. So that's encouraging clients to advocate for themselves when they're ready. That is not saying, I think you should do this, or that is not saying, you can do either one of these things, but if I were you, I would do XYZ. It's truly presenting them with the opportunity to make their own informed decisions. So what you're trying to do is make this empowerment not symbolic. It's a protective factor for your client. So it reduces their re-traumatization and it enhances the quality of your representation. It's so important to be transparent with your clients, especially ones who have experienced trauma and, as we talked about, may have difficulty actually processing their information. Again, this is not because they are stupid or they don't know any better, or you need to step into the shoes of, you need to save them, you need to do this white knight role, but it is so that they can have the time and the space with what their body allows them to process. So clarify why you ask certain questions. I think that's really important as well. Explain how facts of their case fit into the legal elements that you're trying to prove or that you're trying to disprove. And certainly explain what to expect at each stage. So A lot of times clients are just looking to understand the why behind something. So they are more likely, when they understand that why, they're more likely to participate in the representation. They're less likely to feel blindsided, and they're better able to tolerate difficult parts of the process. A lot of times what I have had to explain to a client is, no, that's not fair, or I don't actually know the reason behind this, but this is the way the system works. And if you're being that honest with them, if you're being that clear with them, that you don't know anything, you're just on the same page as them, or that you've had this experience before, again, that enhances the trust in the attorney-client relationship. So when we're talking about ethical considerations, when dealing with people who have experienced trauma, it is very easy to, as we would say at Genesis, step into the shoes of the abuser. It's very easy for us to say, I just know how to do this. I know what's best. Let me just go ahead and do it. And that should be avoided at all costs. So our role as attorneys and advocates is to advise and empower, not to control the client. This, I think, is especially important for us as attorneys because we are given a position of power and a perceived role in society. We're also given access to power structures, to resources, and it's very easy for someone to say, well, you just know best, you go ahead and do it. It's also easy for us, if you're like type A like me, to say, well, I just know how to do this, let me just go and take care of it. It's also very important to explain to the client that not all legal issues have a route to a positive outcome for that particular case. So part of our role may be having to explain that the legal system is not necessarily where you can find justice. It's certainly not a place for vengeance, and it's not always so simple as wins and losses. So that is certainly fulfilling your ethical obligations of explaining. But I think with clients who have experienced trauma, it's more important to go above and beyond with explaining and taking care of the information that you relay because of the way that they can process information, because of the way that you can form those emotional bonds with your clients who have experienced trauma. And again, this is also taking into account recognizing when it's not healthy to stay in the relationship anymore. If you get to the point where you feel like you're being taken advantage of, where you feel like you are staying in a litigation because the client wants to, those are points in time when you consider, is this the right representation? Should I continue to stay in that? So that is something you want to be on the lookout as well. Definitely want to make sure to talk about how trauma can affect all of us who work with people who experience trauma. So this does not leave us untouched. Vicarious trauma, which is also called compassion fatigue or secondary trauma. This can show up in a few different ways, but I would say generally it shows up as emotional numbing or persistent hyperarousal, where you feel like you are constantly on alert, where you feel like you are constantly stretched and stressed beyond a way that is healthy. This is distinct from burnout. It can affect your judgment. It can affect your patience, and it certainly can affect your professional satisfaction. So being on the lookout for these signs is, as with most things, the first step in addressing it. So when we're looking at some of the coping skills that can be helpful in taking care of yourself, these are good practices to adopt or take into account so that you can continue representing these clients and also continue to do your job well. It's important to cultivate self-awareness through regular check-ins. You can journal, tracking moods, using mindfulness, breathing, and movement to regulate your stress. I cannot emphasize the access to support enough. Being able to debrief your difficult cases, being able to have a neutral third party or someone that you can vent to is incredibly important, but also people that you can rely on. So where you can say, I've had too much, I can't do this right now. Can you help me? Can you take over? Those are important ways to make sure that you are being supported when you're dealing with clients that have experienced trauma. Definitely establish your boundaries and make sure that you're honoring them around the time that you give to your clients, certainly around the emotional labor that you give to your clients, and the caseload intensity. I think it's okay to remind ourselves that we can say no in certain situations. If you shut off your email after a certain time, if you need to tell a client, like, I will answer one email a week from you. But setting those expectations and holding firm on those boundaries, that is important to make sure that you can continue with this type of work. And if you have the ability, I think it's good to alternate between high and low intensity matters when possible. So I think the bottom line is that protecting yourself also protects your clients. So in conclusion, what we want to do today, and what I hope we did today, was understand how trauma impacts the brain, and recognizing how trauma can affect our memory, our attention, and definitely our emotional regulation. And it shapes how clients process information and how they respond to stress in legal settings. I hope that you also felt the message that we want to center humanity, not just the legal strategy, recognizing the clients as a whole person whose experiences of trauma can affect their engagement with the legal process. Certainly, we want to be able to promote safety and trust, both for ourselves and for our clients. And most importantly, we want to empower our clients through choice and collaboration. So we definitely want to be supporting client autonomy, offering clear options, respecting boundaries, and co-creating strategies. And last, prioritizing self-care and resilience. So acknowledging the emotional toll that trauma-related work can have on us, can help us sustain our systems and prevent burnout. So hopefully what came across, and what I'll just conclude with, is that trauma-informed lawyering does not dilute your ability to be a zealous advocate. It actually enhances it. So by understanding the way that trauma shapes behavior and memory, we ask better questions, we build stronger records and cases for our clients, and we improve client engagement and client outcomes. So by centering trust and transparency and empowerment, we reduce re-traumatization for our client, and that's how we can improve these client outcomes. And of course, by caring for ourselves, we sustain our capacity to serve. So I wanted to make sure to leave enough time for questions. And I think we have enough time, but I wanted to thank you for your time, and hopefully this is informative to you, and open it up to questions.
Thank you, Rachel, on your wonderful presentation. Seeing no questions at the moment, I will take care. I believe there's possibly some feedback. Okay. So for those of you attending, please self-report your MCLE course credit, and I just put it in the chat, and I will also say it here. So today's CLE was approved for 1 hour of MCLE and half an hour of ethics. So that course number is 174-294-835. Again, that is 174-294-835. And we do have a question come in the Q&A. Thank you. It says, do you have any quick hit tips that you'd suggest for attorneys that weren't able to attend today, complete today's presentation? So abbreviated version of today's presentation.
Yes, I think the most helpful tips are understanding the ways that trauma experiences, that they are not a monolith, that it's not one way across the board, that it has real and lasting impacts on your body and on your ways to function. And the more that we as attorneys and advocates can listen and be on the lookout for those experiences, the more we can take care of our clients and empower them to make their own choices. That's kind of the one sentence, I know that was a run-on sentence, but the one sentence summary that I can think of.
No, that's great. Thank you. And thank you for that wonderful question. Um, just a lot of good jobs. So thank you, Rachel.
Thank you.
Yes, so today's presentation has been recorded, will be made available, and then we will send out a copy of the presentation and information on how to contact Rachel if you do have specific questions, particularly to a client, or how to navigate a situation. Great. Well, thank you all for being here today and who tuned in to this wonderful presentation on how to be better advocates and better attorneys to to your clients. So thank you all, and thank you, Rachel, for providing this presentation. As I mentioned, an email will be sent out with a copy of the PowerPoint presentation and the CLE course code. And if you do have any questions, please feel free to reach out to myself and or Rachel once you receive her contact information. And we hope that everyone has a great rest of their afternoon. And please let us know how DVAP can help you with your cases. Thanks, Rachel.
Thank you.
Bye, everyone.